The issue of abortion has dominated the news after a leaked draft opinion from the Supreme Court that suggests the repeal of Roe v. Wade came into public attention. And so, like many of you I'm sure, I've been trying to make the whole thing make sense. Here's where I'm at so far. Roe v. Wade was a case that was argued on December 13th, 1971, re-argued October 11th, 1972, and decided on January 22nd, 1973. The case involved a Texas law that prohibited abortion except when necessary to save the life of the pregnant woman. The Supreme Court, in a decision written by Justice Harry Blackmun, deemed the Texas statute unconstitutional based on a right to privacy protected by the 14th Amendment, not on the basis of women's rights as it is commonly mistaken. The court applied the right to privacy established in Griswold v. Connecticut, a case decided in 1965, which deemed a law that prohibited the use of contraceptives by married couples unconstitutional on the grounds that it violated the right to marital privacy. This established the basis for the right to privacy with respect to intimate practices. It also helped to build a foundation for the right of privacy as protected from governmental intrusion. Using this idea of the right of privacy, the Roe v. Wade opinion essentially wrote that women have the right to privacy with her physician in relation to abortion without government intervention. Roe v. Wade could have been a landmark case for women's rights to choose if the Supreme Court deemed that prohibiting abortion is fundamentally disadvantaged to females and that the right to choose whether to bear or beget children is fundamental to the course of one's life. Yet Roe based itself on an already established case of privacy. So in the end, it gave women the ability to control their lives, but did it without explicitly centering the case around women's rights. Anyways, that aside, let's look at something that I don't find too convincing in the leaked draft opinion by Justice Samuel Alito. Justice Alito writes, "The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty." He substantiates this claim by saying that until the later part of the 20th century, such a right as abortion was entirely unknown in American law. But in an effort to quote-unquote set the record straight on the history of abortion in this country, Justice Alito can't give any solid examples of laws that support his point. He fumbles around for a couple pages and says, "We are aware of no common law case or authority, and the parties have not pointed to any that remotely suggests a positive right to procure an abortion at any stage of pregnancy." In other words, he's saying that because it isn't explicitly written anywhere important that abortion is a protected right, it is not a right that is deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. I'm going to call bullshit on that. And I say that because of all of the history that Justice Alito leaves out of his draft. Here's the history. And I encourage you, if you're interested, to research this yourself because the things I'm going to say don't even scratch the surface. First of all, I'll just start by saying that women have been having abortions for as long as they've been giving birth. In the Old Testament, Numbers 5, 11 through 31, it says, "If a woman is unfaithful to her husband, she must bring her to the priest who will give her a bitter water that brings a curse that will make the woman miscarry and her abdomen swell." They had abortion all the way back in the biblical days, but it's ironic because even then, women didn't have control over childbearing. Anyways, back to the history. Geoffrey Stone, American law professor at Chicago Law School, writes, "In the 18th and early 19th centuries, the prevailing view was that there was no human life until quickening. Blackstone's Commentaries, 1765, a treatise on the common law of England, for example, stated that life begins in contemplation of law as soon as an infant is able to stir in the mother's womb, and James Wilson, one of the framers of the American Constitution, observed that in the contemplation of law, life begins when the infant is first able to stir in the womb. American courts followed the traditional English common law in holding that abortion before quickening was lawful as long as the mother gave her consent. And Leslie Reagan, a professor at Illinois Urbana-Champaign who specializes in the history of American medicine and public health, writes, abortion was not always a crime. During the 18th and early 19th centuries, abortion of early pregnancy was legal under common law. Abortions were illegal only after quickening, the point at which a pregnant woman could feel the movements of the fetus, approximately the 4th month of pregnancy. The common law's attitude towards pregnancy and abortion was based on an understanding of pregnancy and human development as a process rather than an absolute moment. Indeed, the term abortion referred only to the miscarriages of later pregnancies after quickening. What we would now identify as an early induced abortion was not called an abortion at all. If an early pregnancy ended, it had slipped away or the menses has been restored. At conception and the earliest stage of pregnancy before quickening, no one believed that a human life existed. Not even the Catholic Church took this view. Rather, the popular ethic regarding abortion and common law were grounded in the female experience of their own bodies. I'll get back to the idea of pregnancy as a process rather than an absolute moment later. But the key takeaway here is that abortion before the woman could feel the baby in her womb was legal under common law. Professor Reagan goes on to say, the first statutes governing abortion in the United States were poison control measures designed to protect pregnant women by controlling the sale of abortifacient drugs, which often killed the woman who took them. It is crucial to realize what these early 19th century laws did not cover. They did not punish women for inducing abortions, and they did not eliminate the concept of quickening. Even as poison control measures, they said nothing about growing the plants needed in one's own garden or mixing together one's own home remedy in order to induce an abortion. The legal silence on domestic practices suggests that the new laws were aimed at the commercialization of this practice and implicitly retained to women the right to make their own decisions about their pregnancies before quickening. By the 1840s, the abortion business boomed. Despite the laws aborting the sale of abortifacients, they were advertised in the popular press and could be purchased from physicians or pharmacists or through the mail. If drugs failed, women could go to a practitioner who specialized in performing instrumental abortions. Advertisements and newspaper exposés made it appear that what had been an occasional domestic practice had become a daily occurrence performed for profit in northern cities. The clientele of these busy clinics were primarily married, white, native-born Protestant women of the upper and middle classes. Protestant woman, by the way. Anyways, given how widely accepted and available abortion was for a substantial period of American history, in addition to the pro-choice-esque characteristics of early abortion laws, I would say that there is an argument to be made in contrary to Justice Alito's claim that abortion is indeed deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. That being said, I want to touch upon the idea that in the 18th and early 19th centuries, pregnancy and human development was viewed as a process rather than an absolute moment, because this seems to be the crux of the moral problem in modern discussions about abortion. In my view, there are two camps in regards to the issue of abortion in the US. One side believes what Americans in the 18th and early 19th centuries believed, that life during pregnancy is indeterminate until a certain point. That point evolved through time from quickening to the first trimester to fetal viability, and abortion before that point is completely acceptable. The other side believes that life begins at conception or the fertilization of the egg, and thus argue that abortion at any stage of pregnancy is murder. I think both stances are grounded in unprovable assumptions about morality and when human life begins. In other words, we can argue over whether an embryo should be considered a living human being all we want, but it's something that no one can give an absolute answer to. You can bring in religion or science, it doesn't matter. Nothing can objectively define when human life begins because the idea itself is abstract and subjective. But I will say this. The position that life begins at conception and is essentially the same as a living human being is a stance that is hard to maintain on a logical level. I'll tell you what I mean. Let's say one believes that life begins at conception and thus thinks that abortion at any point after fertilization is murder. Given this person must then also believe any form of unintentional pregnancy loss is involuntary manslaughter. If a fertilized egg fails to implant, which naturally happens a lot, that is the death of a human being. If a mother has a miscarriage, that is the death of a human being. Any form of pregnancy loss must be immoral in the eyes of the person who believes that life begins at conception. So if this person is serious about this moral belief, they should be advocating for the imprisonment of mothers who experience pregnancy loss because involuntary manslaughter is punished with imprisonment in the United States. Now, this stance is obviously ridiculous. But that's what I mean when I say it's difficult to maintain the moral position that life begins at conception and believe that the death of an embryo is the same as the death of a living being. Like I said, anyone is free to hold this view. But they should know that in order to be consistent in this moral belief, they must also believe that any loss of pregnancy, whether it's abortion, implantation failure, or miscarriage, means that the mother that had that pregnancy loss is then automatically guilty of some form of manslaughter. Now let's move to the final issue that I think is important in regards to the potential repeal of Roe v. Wade. What is going to happen to poor women? Let me tell you a story you probably already know. In 1969, a Texas woman in her early 20s wanted to terminate an unwanted pregnancy. This woman had an incredibly difficult childhood, came from impoverished circumstances, and had to give 2 children up for adoption. Pregnant with her 3rd child, she wanted to get an abortion, but the law restricted her from getting one legally. She then, like many others before her, looked to get an abortion done illegally, but was unsuccessful. She did not have the wherewithal to travel to another state where abortion was legal, and so she was stuck. Yes, this woman was Norma McCorvey, otherwise known as Jane Roe, the plaintiff in Roe v. Wade. If Roe v. Wade is repealed, we will inevitably have more Norma McCorveys in the United States. The well-heeled women who have the means to travel will be just fine. They can go to a private doctor in New York or California or any other state that allows abortion and have full control over their lives. But the poor who are unable to afford travel or medical services will be left in the dust. And if history has shown anything, women will die from illegal abortions. Children will be left parentless, and abortion laws will be challenged again. But this violent and depressing repeat of history is something that I personally would not like to see.